Students, today's topic is discharge of contract. This is a little bit lengthy topic, so I decided to divide this topic into 4 to 5 videos. So here is first video regarding discharge of contract. It's a very important topic for the students. Let's have a look on the concept of discharge of contract. Normally, you can say discharge mean end of contract or where contractual obligations come to end for the parties. When the rights and obligations arising out of a contract come to an end, the contract is said to be discharged or terminated. We have a few modes of discharge of contract regarding Contract Act 1872. The list of all these modes are on your screen. The first one is discharge by performance. Second one is discharge by agreement. Next is discharge by subsequent impossibility. Next one is by lapse of time. Fifth one is by operation of law. And finally, discharge by breach of contract. The detail of each mode will be available to you in the coming videos. In the first video, which is part 1 video, you will get the information of discharge by performance. Discharge by performance means here, performance is the natural mode of discharge. When the parties to contract perform their promises, or you can say perform their respective part of promises, the contract is discharged, and this is called discharge by performance. Performance may be classified in two further heads. The first one is actual performance, and second one is attempted performance, also known as tender. Here is a short explanation of actual performance, or you can say what happens in actual performance. When each party to a contract fulfills the obligations arising under the contract according to the terms and conditions of the contract, it is called actual performance of the contract, and contract comes to an end. In simple words, students, you can say nothing left to perform when both parties perform their respective parts of their promises. This is a case of actual performance. To support this, here comes example. A agrees to sell his cycle to B for rupees 5,000. A delivers the cycle and B makes payment. There is actual performance. Now you can see in this example, nothing left on the part of A and as well as on the part of B. Both parties have performed their respective parts accordingly. The next one is attempted performance, which is commonly known as tender. It is also called offer of performance or attempted performance as well as. When one of the parties to the contract offers to perform the contract, but the other party does not accept it, there is a tender. It is not an actual performance, but is equivalent to actual performance. Now you can note here, in this particular scenario, one party is going to perform, or you can say willing to perform his part of promise, but his performance prevented by the other party. Example, A agrees to sell his book to B for rupees 1,000. A offers to deliver the book, but B does not accept it. There is offer of performance from A. So you can note from this example, A is willing to deliver the book, but B is not going to accept his offer, or you can say is not going to accept his delivery. So this scenario is called attempted performance or tender as well as. Here comes a few essentials regarding tender, or you can say which attempted performance is valid or which attempted performance is not valid as far as law is concerned. So first essential regarding tender is it must be unconditional. It means if tender is conditional, the other party is under no obligation to accept it. For example, a debtor of company B, offers to pay if shares are allotted to him at par. It is not a valid offer. Now, students, you can note that in this example, in this attempted offer, the condition is imposed by A to company B. So when someone imposes condition for the performance, that tender is not a valid tender. The next is it must be made at proper time and place. For example, A is tenant of B, offers him rent at marriage party. B is not bound to accept, as the tender is not made at proper place and time. In this example, the offer from tenant to B was not proper because B was in marriage party. So here the offer from A was not made at proper time and place. So in this view, the tender is not a valid tender. The third one is it must be of the whole obligation. An offer to perform a promise in part is not a valid tender. For example, A is a debtor of B, himself decides to pay in installment and offers the first installment to B. It is not a valid tender. In this example, the debtor himself decided to pay to the creditor in installment without the consent of creditor. So this scenario explains that this offer is not a valid offer, or you can say this tender is not a valid tender. Fourth one is it must be made by a person who is able to perform a promise. Students, for example, a tender by minor or idiot is not a valid tender because minor and idiot does not enjoy a capacity to perform their obligations, or you can say minor and idiot cannot be held responsible to perform their part of promise. The next one is it must be made to promisee or his agent. A tender made to a third party is not a valid tender. For example, A was liable to return the goods to B or his agent C, but A returns the goods to X. It is not a valid tender. The next one is if there are several joint promises, tender to anyone is valid. For example, A gets chairs on rent from K, L, and Y jointly. A can returns the chairs to any one of them. The last and final essential of valid tender is, in case of money, exact money should be tendered. Students, for example, tendering 5,000 currency note to a conductor of a bus for a ticket of 100 rupees is not a valid tender. So this is all about first mode of discharge of contract as well as few essentials of valid tender. Remaining modes, inshallah, you will get in the coming videos. Goodbye.